Morning, everyone, and sorry for the delay. I know Crimes Against Children Narcotics had planned to meet at 9 o'clock this morning. There was a disaster on 75, and I know that's going to get put off till this afternoon. Do we have any information on time and place for Representative Weldon?
Mr. Chairman, it's going to be dynamic based on Representative Ramsey's committee, and again, the only bill we've got before us is 184.
Right.
It's just going to be a vote. We've got a substitute that's come through 15 or so amendments from the last subcommittee. So, you know, at the pleasure of yourself and Chairman Ramsey, we'll make that call.
Okay, and Mr. Ramsey, when is your meeting? All right, so
We've got a lot of work to do.
let's just see. Maybe we can get your subcommittee in right after Mr. Ramsey's committee.
I can tell you, Mr. Chairman, it's going to be Representative Weldon explaining 3 changes and taking a motion. So.
I'd be happy to defer my meeting.
Given the alleged brevity, as described by the affiant Mr. Setzler.
Is he
about 50 witnesses? Maybe we'll do that. That would be more expeditious. Maybe, Mr. Weldon, that sort of gets you where you need to be procedurally, and then we'll march on from there. Let me thank you for everybody's flexibility on that. Let me recognize Judge Ray. Where are you?
Chairman, Judge Ray's on his way. He's not here yet.
Okay, there's a lot of that going around this morning. Billy Ray's no stranger to this room and many people here, and we look forward to having him here. Let me also remind members that there's going to be a lunch, since this is truly an ongoing process today. There's going to be a lunch for members of the committee over in 133, as you are able to make your way over there to fuel the machine and keep things going. Let's get right to it then with, let me call on the governor's floor leader for House Bill 503, Representative Carter.
Thank you, Mr. Chairman. Members of the committee, I bring before you House Bill 503. Before I begin on the bill, I want to give you a little history of the Crime Victims Emergency Fund, which is what we're discussing in this bill. The Crime Victims Emergency Fund is a funding stream that allows victims of crime to apply to receive money to cover expenses related to the crime, such as their medical expenses, counseling, funeral expenses, or lost wages. The fund receives money from DUI fines, from parole and probation fees, and from a federal VOCA, or Victims of Crime Act, grant. What this bill does with that money, which is currently sitting there, is we're asking through the bill to use some of this Crime Victims Emergency Fund money to pay for the forensic medical exams for victims of sexual assault. What's currently happening is that local law enforcement agencies are having to pay these medical costs. They're having to pay for these forensic exams, and this will simply shift it from the local governments having to pay for it to this Crime Victims Emergency Fund using its monies to pay for the forensic exams. I'll give just an example of my local government. Our Valdosta Police Department budgets about $12 million a year for these forensic medical exams, and by using this fund, which the criminals will be paying into, it allows us to take some of that grief off of the local governments. You'll see throughout the bill there's simply the striking of law enforcement agency to changing that to the Georgia Crime Victims Emergency Fund, so that it will.
Ms. Carter, let me ask you. I apologize for the
Okay.
interruption. Let me ask you to suspend for just a minute.
Sure.
I think don't have the complete bill in our file, do we? Does everybody have?
It's 503. It's 2 pages.
Okay. Let's hold for just a moment. On the second page, is there anything
On the second page, which section 4 reads
substantial?
that when a forensic medical exam is conducted, the cost of such exams shall be paid for by the fund in an amount not to exceed $1,000.
Okay, if you would, I apologize again, but we don't have the second page of the bill.
Sure.
So we'll take a couple minutes. Let's just be at ease with an awkward silence and wait for the wait for that second page. Thank you.
How have you been?
Insanely busy. How are you liking being a Florida?
I love it. I'm so busy. I know.
That's good.
You talk to Gina a lot?
I haven't. Have you? I just feel so badly for her. She seems to have a pretty good attitude about it. Betsy's talked to her.
Has she? I hadn't even asked Betsy.
Yeah.
Mm-hmm.
And she just quit her other job. Of course.
That always happens, it seems like.
But, I think she was interested in exploring other options. Sometimes
She has been, yeah.
It's the push you need,
Oh, I'm sorry. And I wrote. Oh, okay.
Okay, we've got to apologize for the interruption, but we probably do better to have the actual bill in front of us,
Thank you, Mr. Chairman.
or the whole bill, I should say.
And forgive
So
me,
please continue.
I misspoke when I said Valdosta pays $12 million. It's $12,000, that we budget for these incidences per year. But if you will look at Section 3 with me, the forensic medical exam means an exam, and you'll see the A through E, an examination for physical trauma, a determination as to the nature and extent of the physical trauma, a patient interview, collection and evaluation of the evidence collected, and any additional testing deemed necessary by the examiner in order to collect evidence and provide treatment. You also see, as I said before, in Section 4, there's a cap on the amount paid per exam of $1,000. I will say in the state of Georgia, the average cost for an exam is $450. And also to mention, there are 23 other states which utilize this fund or similar funds within their states to cover the expenses related to these medical exams. If there are no questions.
Tell us again how much is in the Georgia Crime Victims Emergency Fund.
Well, it collects around $24 million per year, and after discussion with OPB, they said this is a fiscally sound measure to use. And it just continues to add funding because as the criminals commit the crimes, they pay in these fines which go into this fund.
It's one of about 20 or so add-ons that we've done over the years. Tell us, you may have said this, Madam Floor Leader, and if you did, I apologize, that the fund is also used for what other purposes right now, generally, without being exhaustive on it.
I'm not.
And if you need to defer to someone, that's fine.
Come on up if you'd like to.
Thanks.
Thank you, Mr. Chairman, members of the committee. My name is Shawanda Reynolds-Cobb, and I'm the Division Director for the Georgia Crime Victims Emergency Fund, and we use those funds to pay for medical, funeral, mental health counseling, loss of support or lost wages currently for crime victims.
Generally, what's the Representative Carter said about $24 million a year is collected. What goes out the door generally?
Around $18 million to $19 million per year.
What's the projected from what you've, well, if there's even a way to quantify it, is there a projection on what the additional cost to the fund would be in order to go ahead and?
$3 million.
Okay. Mr. Vice Chairman.
Thank you, Mr. Chairman. Just a couple of things. Is there there's not a provision in here that I say in the event that a person is found to have made a false allegation, or in the event that that ultimately that a claim is shown not to be true, there's not any way to have a clawback, so to speak, for that money?
Currently, what we're trying to do also at the Criminal Justice Coordinating Council, we administer VAWA, Violence Against Women Act grant, which brings in $4 million a year to the states. And the language that you see in the bill, that's the language that's needed in order for the state to qualify for these funds. So it doesn't require that the victim report or cooperate with law enforcement, and that was a measure that was passed several years ago. So we're just trying to make sure that we are in compliance with the VAWA guidelines.
So you're telling me that even if someone makes a fraudulent report and then as a result of that we pay out up to $1,000 out of that fund, that there's no way that we cannot, as a state, cannot recoup that money?
What we can do in our admin rules, those are things that we would normally take a look at. When we add anything new to the Crime Victims Emergency Fund, we have a Crime Victims Board that we work with, as well as our council members that make up the members of the criminal justice system. So anything that comes up that looks like we're going to have a problem with either someone trying to fraud the system or expenses that are really not, how can I say this, expenses that are above and beyond what you would think you would pay, then those matters are addressed by our board and council members through administrative rules.
Okay. So there are, Are there rules in effect now that address fraud issues?
There are rules in effect now with the Crime Victims Compensation Program as it stands, yes. And of course, since we don't have this yet, we don't have any admin rules in place at this time that would address these issues, but we would put some in place.
Okay, thank you.
Thank you, Mr. Chairman. I just have two questions. By doing this, will it exhaust the fund that you previously had, so you can't even take care of the other obligations that it's originally used for? Is that what as you said, it's only $3 million? Okay. And the second question is, will the victims have to apply, or is it automatic, or is it kind of billed to them, or would it be reimbursed upon determining if a rape or what have you had occurred? How would that work?
Okay, to answer your first question, no, it will not exhaust the funds. This is something that we've been looking at for the last 2 years, and we've been working with the Office of Planning and Budget on as well. To answer your second question, the way that it works currently, and we would continue to do this, is that the providers would send us the bill directly. And in our agency, we have individuals that are specialized in billing and coding. They would review those bills, and then they would pay based on their review.
Okay. If I might add a follow-up, could it be a safeguard to have it where we could be billed, but it won't be paid until it's been determined that an actual crime has occurred? Could that be something that?
I think one of the things, and I have my colleague here, because the thing that we are also trying to do, part of the reason why we have the bill is because we are really not in compliance already with the VAWA guidelines, and what we want to make sure that we do is that we stay in compliance so we don't lose that grant.
Okay. All right. Thank you, Mr. Chairman.
Yes, thank you very much. Are these exams not being paid for now? I know you said it's through the county, so are they denying people the ability to have these tests done?
We just had a study completed with law enforcement through Georgia State University, and what we're seeing is that there are some instances where either the victims are being denied the exams, or they are being billed, which they should not be, according to current state law, as well as the VAWA guidelines, or there's a lot of discretion being used as to whether or not the victims will be allowed to receive the exam. So all of those things are reasons for us to be denied the VAWA funds in the future.
And Mr. Chairman, this question is, I think, for you. Did we not just pass the sexual trafficking, which will also now tap into these dollars?
I would have to go ahead and, I'm seeing a head nod, so I don't recall personally off the top of my head if HB 200 directly contemplated that, but I'm getting an indication that it did.
Yes.
So is that not going to affect the amount of money that's drawn out of that account?
Currently, we are already paying for those exams in today's world. What that does in HB 200 is it makes it a little easier for us to actually process those claims. Right now, it takes us a very long time to get them processed just because of the way that those crimes are reported. So it's really not an addition to us. It's really just putting into law something that we're currently working to do.
Further questions?
Sure.
So what you're saying, and from the sexual trafficking bill, we've already been paying all of that already?
We've been paying, we've received claims in the past already where we've been asked to pay for counseling for those crime victims. And the current statute is nothing that prevents us from paying them. I think what has happened, though, in the past, it has not been very easy for us to pay them. So what HB 200 does, it really solidifies in the future our ability to pay those claims.
There's nothing in that statute that prohibited. There's no express prohibition.
Right.
So it ends up being, permissive, I assume, on a case-by-case basis and so forth.
Yes.
Okay. Mr. Pack.
Thank you, Mr. Chairman. My question is actually about funding. It looks like the bill's intent is to take some of the burdens of the local government in paying for these tests onto the state fund. question, I think there was an add-on to the probation and things like that goes into this fund. Am I correct in saying that? What is the, are there a couple local governments, besides the add-on by the probationers and things like that, are they contributing to the fund, like the counties and the cities, or is that just solely based on, so it would be shouldering a burden solely by the state? Okay, thank you.
Mr. Setzler.
Thank you, Mr. Chairman. Just a question. I mean, to me, this seems like of all the uses of the fund, this seems like is reasonable of a use. I mean, as I read line 14 and 15 of the bill, to the extent that the expense is incurred for the limited purpose of collecting evidence, I don't see any real ability to use this for broad reasons. It's a fund that this legislature's seen. I would submit much looser purposes for in the past. To me, it's very limited use. What's the cost of each test? Do you know by chance?
It's an average of $450 per test, and that includes the exam kit, the nurse and physician fees, the facility fee, and the medical lab fees.
Okay. How many a year are we doing in Georgia? Do you have any sense of that?
There are approximately 3,000 of these administered a year.
So 3,000 a year. Yeah, Mr. Chairman, I just, talking about a crime victims emergency fund use for collecting evidence for criminal investigation. I can't imagine a better use for that than this, and this is certainly not something that I could ever imagine putting back on the victim. And with that in mind, Mr. Chairman, I'd be prepared to make a motion if it pleases the chair.
Duly noted. Let me go ahead and go around the horn one more, complete the table. Ms. Benfield.
Oh, I just have a quick request. You'd referenced a Georgia State study, and I would love to see a copy of that.
Okay, will do.
And I'm sorry, I came in late. Can you identify who you're with and what your name is?
Yes, my name is Shawanda Reynolds Cobb. I'm the Division Director of the Georgia Crime Victims Emergency Fund, and I'm with the Criminal Justice Coordinating Council.
Thank you.
You're welcome.
Ms. Abrams.
Thank you. Is it not true that, I know there have been some queries about fraud, but is it not true that to the extent you include fraud provisions in bills such as this, it has a chilling effect on reporting because victims become concerned that if they are not found to be, that there are other reasons that a case may be dismissed, but that if they're afraid of fraud, you will actually chill reporting and miss the opportunity to actually adjudicate some of these crimes?
Yes.
Thank you.
Thank you.
That's all we've got, Representative Carter. Thank you.
Thank you
very much. Rebecca DeHart with the Georgia Network to End Sexual Assault.
I'll just be very quick. I'm Rebecca DeHart with the Georgia Network to End Sexual Assault. There are 27 sexual assault centers throughout Georgia, and we're very supportive of this legislation, and thank you for your time.
Thank you for your statement. I see no one else signed up to speak on House Bill 503. With that in mind, what's the pleasure of the committee, Mr. Setzler?
Mr. Chairman, there's a gentleman out there.
Oh.
I'm sorry, Chairman. I thought I signed up for that.
I just have one name here, but you can certainly, if you'd like to be heard.
I'll be very brief. Excuse me. I'm Greg Laughlin with the Georgia Commission on Family Violence, and our 37-member commission voted unanimously to support this proposal and using the victims' comp funds for this purpose, and really appreciate your leadership and hope the committee will look favorably on it. Thanks.
Indications are good. Mr. Setzler.
Mr. Chairman, move to pass HB 503, LC version 294722EC.
Move to pass House Bill 503, LC 294722-EC, second by Mr. Pack. Any further discussion? Are there any amendments? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you. Thank you, Representative Carter. We had previously under consideration House Bill 336 by Chairman Davis. You have a substitute in your file of LC 294664S. Recall this is the subpoena/sworn testimony bill. There was some wordsmithing that went on in the interim, try to go a little more toward perfection of the process on this type of thing. Chairman Davis, let me just ask you if you could speak to the, I think it's pretty straightforward, but please speak to the changes, if you would, in the substitute here as opposed to what we the as introduced version.
Yes, sir, Mr. Chairman. In Section 1, one of the questions that came up during the previous hearing was putting all the power under the one person within the House or the Senate, and bringing the committee process into the request for subpoenas. And the first section goes right into that, where we will, each committee that's on the committee list on page 2 will have to go in at the organizational meeting and set standard rules for the process of which a subpoena would be requested of the Speaker, or the President of the Senate, or the President Pro Tem of the Senate. Now, the power still lies within the Speaker and the presiding officer of the Senate. However, there is a process now within this language here that it would be done in writing, and it would be done by an action of a committee to request it. And that was that was a lot of the discussion from the first hearing. There's really no changes on page 2 with the committees, the same committees, and all the striking on page 2 and 3 is from the previous process of issuing subpoenas through the Committee on Ethics, which is on our new list. So the other substantial change at the end of Section 1, Representative Pack was very concerned about confidential information, and if there is a subpoena with information that is something of delicate nature or private nature or business nature that the chairman is brought aware of, then he could protect that information under the Open Records, from the Open Records Act, under Article 4, Chapter 18, Title 50. That's that E section on lines 104 through 107. Additionally, after hearing the testimony of the committee, we discussed separating the subpoena power from the sworn testimony power. Section 2 is the new section on the sworn testimony, and it will not be limited to the list of committees that have the subpoena power. It will be for all standing committees in both the House and Senate, and the sworn testimony could be voluntary by the chairperson of each committee, and it puts forth the language there, including the oath that the person testifying before the committee will have to do, in the process for which that goes for. And that's pretty much the changes from the original bill, and Mr. Chairman, I'll be happy to clarify anything else if need be.
And just a couple of observations. This is the type of subject matter that you have to approach carefully in order to avoid a potential but unintended overreach in our practice and procedure here. There, I know, was some discussion in Section 1 about that, each of the committees may adopt committee rules, so it's permissive as opposed to shall. There may be a need on the part of the chair, on the thought of the chair of those respective committees to go ahead and do that or not. I can tell you that for my purposes here, should this pass and be signed, I would probably endeavor to propose rules to this committee for adoption during the special session in preparation for the next general session in January, just as a matter of information for us here. As far as the testimony goes, I know there was some discussion regarding, well, why not just go ahead and have everybody sworn? Which, I mean, there's something to that. Because I think one of the main observations we had during the last meeting was it isn't so much getting people here, it's making sure that we're getting the truth when they're actually in the chair. But that can be a case-by-case basis, and there are times when that may not be necessary. There are times that maybe perhaps the chair of a respective committee that's on the list might feel as if that might actually have a chilling effect on testimony. And so I think the thought was, members of the committee, that we do better to have some latitude as to whether or not to employ that procedure or not. Better to be able to make that decision on a case-by-case basis rather than trying to force a particular procedure that may not be appropriate, at that time. So that's my thinking on it. I think we do better to err on the side of caution as it relates to that. We might get to the point where if this, again, it becomes law, we might get to the point where just as a matter of customer practice, everyone swears in a witness, whether it's on a full committee or subcommittee. I don't know. We may get to that point, and then we go ahead and codify, on the heels of that. But I think just moving slowly on this, is discretion is a better part of valor on this one. So I just wanted to give the committee my thoughts on it as it relates to this committee, for what little that may be worth, and recognize the vice chair.
Thank you, Mr. Chairman. A couple of questions that I had on this. Is there any, what is the basis that we would allow a subpoena to be issued for anyone and compel them to come and appear before the committee, rather than simply requiring that any testimony before the committee be given under oath?
Well, and that was a lot of our discussion in the previous meeting.
And I'm sorry I missed that.
This is going to be the exception, not the rule, on the subpoena. Having the power to do the subpoena really, sometimes just having the power is enough incentive for someone if you ask them to come. And obviously, you don't want to be issuing subpoenas every other day and hundreds of subpoenas every year. So I think it's the exception, not the rule. But I do feel like that there's certain things that certain committees that need to ensure that they have the proper person that's there. Maybe not an underling or something like that maybe they want to pawn that off or something to that effect. But I think it's something that's needed. I think that the discussion was healthy in the previous committee meeting about the biggest problem we have is getting the truth. And when we're making decisions like this committee and the judiciary make, dealing with people's lives, and you got the death penalty and things of that nature, it's important that when we make decisions based on the information given to us, that we get the truth. And obviously, I went out with a budget standpoint as well. When we're dealing with billions and billions of dollars of taxpayers' money, we want to make sure that when we're making adjustments and appropriations, that we're making those changes based on accurate information. And that's what this is about. But the subpoena power itself is going to be something that is used on a case-by-case basis, on just maybe hard to get people that don't want to testify before us.
It seems to me that there's a difference between perhaps requiring somebody who's, say, a government employee or government official to appear and give sworn testimony, and requiring a private citizen to do that. Do you have any concerns that there would be instances where the authority would be abused and private citizens may be subject to basically harassment?
Well, I mean, I can't scenario every situation out there, okay? We are a citizens legislature. The leadership of a committee, if the committee goes rogue, there is a checks and balance there where the speaker can say no to the request. If we have an issue with a speaker that down the line that might have a problem and be issuing too many, there's an election process there as well. I don't foresee a mass abuse of the system with this, but
just as a practical matter, my apology. Just as a practical matter, we don't want to have chairs just being able to issue subpoenas willy-nilly, which is why we have the check of going through a leadership, position. Obviously, the speaker and the lieutenant governor on the other side. Also, if you were to have a presiding officer who would abuse that authority, the individual who would be receiving the subpoena could also move to quash that subpoena if it were frivolous in nature or not needed, or whatever the rationale or reasoning would be. So you have the check there, which of course we wouldn't
Is that in this bill? As far as a motion to quash being available?
I believe. Would that be necessary to have put in there, or is that just a matter of right to be able to go into Superior Court and move to quash?
I don't know. I think it would.
My
it would
presumption
be worth
is that they
taking
can
a
just go
look
in.
and
They can just go in and move to quash, and if they can quash it, fine. If they can't, they can't.
that would, I think, would be worth us taking a look at. But if I may, Mr. Speaker, Mr. Chairman,
I just wanted to
sorry about that.
Inject that. No, not at all. I just want to make sure that you had the background and context from the last meeting.
One other thing I wanted to ask is what the standard for issuance of a subpoena under this bill, and I was looking at in Section 1, subsections A and B that are at lines 19 and 24, and it seems under subsection A, it says, if a committee determines that a subpoena is necessary, the committee chairperson shall communicate, etc. But then in subsection B, then it would provide that if the President of the Senate, President Pro Tem of the Senate, or the Speaker of the House determines that the effective functioning of a committee, it listed in the subsection, requires the issuance of a subpoena, then it would be issued. So is that sending conflicting signals about exactly what is the standard, or in what instances it's appropriate to ask for and to issue a subpoena?
What we're envisioning with this is that if a member of a committee has an issue and they want to issue a subpoena, they would request it of the chairperson. And the chairperson would bring it before the committee, under their rules and whatever their quorum and their vote tallies are for that committee, that an action of the committee to ask in written request of the presiding officer, the speaker in our case, okay? If this committee determined that there was a subpoena necessary and they got, Billy Joe the subpoena, and they passed a resolution saying that, we need this person, we need to compel this person to testify before us, then that resolution with this vote total would be sent to the speaker, and then the speaker would determine the appropriateness of that request before the subpoena is actually issued. So the committee itself cannot issue a subpoena; they can only request a subpoena.
Right. I understand that. I was just asking about if those subsections present conflicting standards as to whether or not a subpoena would be issued. Let me ask.
I don't think they're conflicting. Okay. To answer the
Okay.
question directly, I don't think they're conflicting. I think they're complementing themselves. It has to go through the committee process, and then after it's done all that, then they have to justify it to the speaker.
Okay. One last question. And I will go back through and look at this, but does this bill, would this contemplate a subpoena ducis tecum to be issued? In other words, for not only to appear but to bring documents?
Yes, sir.
Okay. All right. Thank you.
Or just documents.
Let me ask counsel on the vice chair's question regarding a motion to quash. Is that something that we would have to affirmatively codify or put in this the legislation, or is that just inherent?
I have seen, we have had legislation
Yeah.
where we spell it out, but I don't know that it's, it certainly is not part of the statute as it existed. This is the statutory provision for the ethics committee to seek a subpoena. So I can't answer you with 100% absoluteness. I don't think that there would be anything that would prevent somebody from going to court. If you look at line 92, it talks about if somebody fails to obey a subpoena, they can go in. It's just, a little bit different than filing a motion to quash.
Judge Ray, let me catch you off guard if you don't mind me doing so. And if you would care to share any thoughts about that, and if you don't, that's fine too. I haven't asked you about this previously. This is on, if you've been following this, I know you just came in a few minutes ago.
Well, typically we deal with motions
Civil Practice Act, so we would look to the Civil Practice Act, whether or not the discovery assault was germane, that's more of a legislative term, whether it was reasonably expected to lead to discovery of physical evidence. And so we would have some guidance there. On a motion to quash, and if I was a subpoena like this, I would think we probably have the inherent authority to do it, but I'm not sure what standard we would apply unless you told us what standard to apply. Otherwise, you'd be leaving it up to the appellate courts to tell us. And so, it probably would be helpful to have some kind of guidance on if someone wanted to quash a subpoena, what are we supposed to look for? Because I wouldn't be real sure. I don't think it'd be a defense because I don't want to. It might be a defense that I'm not physically capable right now. I'm ill, something like that. But beyond that, I think you would probably need to tell us what you want us to look for.
So we would, out of an abundance of caution, we would do well to go ahead and define the standard.
I think so. That way we would clearly know under what circumstances would you want us to consider quashing a subpoena to testify.
That's good coaching. Thank you, Judge. Mr. Ramsey.
Thank you, Mr. Chairman. And I apologize if I missed this at a previous meeting. Have you provided any information on what other state legislatures do in this regard?
No, I have not.
Okay. Are you aware of?
I am not.
Okay. Thank you.
I would hazard a guess, and it is a guess, that we're probably a little bit behind on this. Maybe not horribly behind, but behind. Ms. Neal.
Thank you. I kind of have one's twofold and one's a little more detail. First question is, does this include falsified documents that are like dispersed to the committee or what have you? And also, as a matter as far as what's considered false testimony, would the stats given by a person be included as well? Because kind of like stats are discretionary depending on who you reference. And along those same lines, would we operate the way we've been doing, or would it be a majority vote or unanimous vote? Because I'm thinking if it's giving us the choice to kind of go forward with prosecution, and half of us, as far as a matter of discretion, feel like, for instance, the stats were okay for me, but if the stats are not okay for another representative who's referencing another source, if we move forward with prosecution as a body and we all don't want to go that way, how are we going to, it's going to be gauged as far as a unanimous vote or majority? How would that work?
Well, I don't think the bill goes to that. The prosecution is not going to be within the committee process. The prosecution is going to be through the court system and through the law enforcement. If we find that there's false testimony, then we would provide the evidence to law enforcement. It would not be a prosecution from our committee or the body.
Okay, and also about the documentation too.
The documentation side of it, I mean, obviously, when we're dealing with information like this, they have to knowingly provide false information, knowing that it was false and intentionally trying to deceive us and whatnot. So, if you have a statistic and they tell us it's 29% and it really was 32%, as long as they believed it to be 29%, they're not going to be in violation of this.
Thank you.
Ms. Bird.
Thank you, Mr. Chairman. Representative Davis, is our system broken, and what is it that we're trying to fix here? If you would please explain that to me.
Well, all we're trying to do is provide for the House of Representatives and the Georgia State Senate to make decisions based on accurate information. And as I believe from your own testimony in the previous thing is that we're not always getting the truth, and that's what we're after. So I don't necessarily think the system is broke. I think we have one of the best systems in the world, but there's always improvements to anything, and I think this will provide that improvement.
Thank you.
Ms. Benfield.
Thank you. A lot of the concerns that I have already been expressed, particularly by Representative Hatfield. I think that there are conflicting standards here for issuance of the subpoena. And Representative Davis, you stated you've got to go through the committee process. But in looking at subsection A, it just says that the committee adopts committee rules, and the rules could certainly give the chair unilateral authority to issue a subpoena. There's no standard articulated other than it's necessary. I know the rules would have to be adopted by a majority of the committee members, but I've got some real discomfort with the wording of subsection A. Subsection B, the only standard I see is effective functioning of a committee. I think that's a really broad standard. It's not even required there that the evidence or the testimony is necessary for a bill that's actually before the committee. I agree with Judge Ray that you've got to have some guidance on the standard. And I know you say you don't foresee mass abuse here, but I think there are a lot of unintended consequences to this bill. I'm especially concerned about subjecting a private individual who's not familiar with legal proceedings to force them to file a motion to quash, familiarize themselves with civil discovery process. Even I have trouble sometimes with civil discovery, and I went to law school for 4 years and have been practicing law for 20 years. I think this is a lot to ask a private individual, and it could potentially be great cost and inconvenience to the individual. And I'm just thinking, my 13 years here, I can't think of a single situation where someone I wanted to testify on behalf of a bill or to bring evidence did not show up, except for valid reasons. And I can think of a couple situations where a witness was in Europe, maybe had family vacation concerns, and we could potentially be subjecting someone who's got tickets on a long-awaited family trip to force them to come here to this committee or any other committee to testify. So I've got serious reservations about how this could impact the unintended consequences of how this bill could impact private individuals. And I really question whether it's necessary, and welcome any of your feedback on those concerns.
I don't know that there was even a question in there. I think it was more your straight opinion. And
those are my concerns, and anything you can do to alleviate those concerns. But my main concern is the unintended consequences.
Well, I think in Section A, which was your first comments on the committee process, I'm most certainly open to making that may a shall, and also making it a majority vote of the committee. It's spelling it out a little bit clearer. I don't agree with the conflicting standards in A and B, because A has to happen before B happens. So the committee has to act before the speaker can act. And maybe I'm misunderstanding both yours and Representative Hatfield's objections there, but I don't see the conflicting nature of it, because you won't have any action in section paragraph B by the Speaker or the President of the Senate if there's no action in A. One can't happen with the other. So, I'm open to clarifying that. We did not discuss in the previous hearing about the motion to quash and using some of the Civil Practice Act, and I would be happy to put that in the bill as well. I'm not after putting something out that's less than perfect, or as close to perfect as we can get, because obviously we all know in this room that nothing we put out is perfect, but I think this is needed. As I stated, the very nature of what we do down here requires us to make some very difficult decisions that affect and impact people's lives, and to ensure that we're getting accurate and truthful information, I think is very important.
For what it's worth, the shall, as opposed to may in line 19, I believe is well taken, because then you have a situation where you could have some committees not adopting some rules, and then some committees adopting such rules, and then some committees not doing that. We probably do better to have some consistency there. But as a practical matter, we are looking at a system of checks and balances where, again, as a practical matter, when you're looking at who's testifying and who's not, a private citizen comes in to testify, or we want to get their testimony. I think just by virtue of being invited to testify, they're going to show up. The question really is, again, getting the truth and making sure we get the truth when they're here, and that, of course, goes to the sworn statement, sworn testimony, aspect of the bill. As a practical matter, you're talking about, individuals not coming in, it's probably not in this particular committee. I really foresee that more in a procurement investigation type of situation. Anything having to do with government contracts, that's when you start seeing individuals not showing up, not being cooperative. Is that something we would see here in this room? No. Is it something that our friends in the Appropriations Committee could potentially see? Yes, it is. And there are other oversight committees in this building that could potentially see that. The question is, how do we address that without being overly broad? And that's a delicate balance. I'm the first one to say so. It's a delicate balance, erring on the side of caution. But I think the observation on shall and having a defined standard on the motion to quash, we probably do better to address that directly in the bill as opposed to just leaving that to the appellate courts, years from now. Ms. Abrams.
Thank you, and thank you, Chairman Davis. My concerns, and I do have a couple of questions, but my concerns come from the fact that these powers are accorded to us through the Ethics Committee because we are a self-policing body. And because we're a self-policing body, we had the right of compelling subpoenas because we are required to conduct our own investigations. The expansion of this power to the list of committees that are in here concerns me for many of the reasons that have been stated before, not the least of which that we are going to compel state, local, and federal, potentially folks dealing with federal issues, to come before us. And they have obligations to their employers. My concern, and the question I have for you, is whistleblower protections. Because if we're going to compel appropriations to bring forward persons who are employed by the state or employed by local government to give sworn testimony that may be contrary or more expansive than what they have been authorized to provide, that may somehow compromise their obligations and their responsibilities, I don't see anything in this language or anything in our existing code that provides those persons protection from retaliatory action by their employers. By the same token, when we have law enforcement officials who would come before this body to give testimony, I think everyone in this body has seen that we have folks who will come and give the answer they're supposed to give, which is not untrue, but the questions that we ask may not have been anticipated, and they would be then sworn to provide full and truthful answers, which may go beyond the scope of what they should know or do know, and we may find ourselves in an investigatory position that we are not, as a committee, I think, situated to be in. And so my two questions are, would you be willing to, or do you include in this bill any whistleblower protections against retaliatory actions by employers? And secondly, because that could come up, and I think this goes to what Representative Benfield was alluding to, you're going to be requiring, in order to avoid answering a subpoena, if for some reason there is information we do not possess that someone who's being compelled to testify may possess, they may seek to quash the subpoena and they may follow the process. That is going to require that they secure attorneys. That's going to require that we may be requiring ordinary citizens and employees to seek legal counsel in order to determine their rights and their responsibilities. And that is an extraordinary burden, I think, for us to put on, for a lawmaking, rulemaking body or policymaking body to place on ordinary citizens or employees. And so my second question is, have you taken into consideration any obligation on the part of this body to help provide for legal support, because they are going to have to navigate a court system in order to quash a subpoena or even to seek limits to their testimony. And so I think, to the chairman's point, this does require a delicate balance, and my concern is that this bill does not get us there just yet, because there are some ancillary and I think very troubling pieces that come from this, given the nature of who we are, but the expansion of what this body will be able to do under the terms of this legislation. So if you can talk to me about the whistleblower protections and attorney protections, I'd appreciate it.
Thank you, Madam Leader. First, on the whistleblower protection, it does not reference it in this piece of legislation. However, it is my understanding that Representative Jacobs just a couple of years ago passed a Whistleblower Protection Act, and we might have to look into the code section on that. But Representative Jacobs carried a Whistleblower Protection Act maybe 2-3 years ago.
I think it was me, but I'll give him credit.
The chairman carried the whistle. Sorry about that.
Not at all.
But
there's a remarkable resemblance.
Yes. Speech pattern. So My understanding, that's already law, and I don't know if it needs to be referenced in this bill, if it's already in the code section or not, but
if I could ask, because I do remember
Sure.
that legislation, I think I voted in favor of it, but that had I'm not certain that the scope of that legislation covers my concern, given what this would be requiring in terms of sworn testimony.
The real issue there is the fact that we don't know, because it really comes down to what is, and it's speculative. To back up even further. That, I think, as usual, I agree with some of what Ms. Abrams said, but not all of it.
I know that's painful.
Well, it is what it is, and it's the beauty of our system that, unfortunately, I think the lady's point earlier is premised on the fact that this is going to be some habitual practice, when in fact, in practical application, it's not. 9 times out of 10, just by virtue of having that power, it gets people here. And again, the issue is not what's here. The issue, getting someone here, the issue is making sure we get the truth once they are here. Also, it's important to remember that it's designed, at least at this minute, to make sure that, number one, it has to be adopted by the committee, pursuant to committee rules. And we should, in my opinion, we should change that to shall, from a may to a shall, as per Ms. Benfield's point earlier, and it's well taken. Then that particular request has to go to the presiding officer, who may or may not issue the subpoena. Now the question then becomes, when the person comes in there and gives a truthful answer that may or may not have a negative effect on their employer. What is it, a public employer or is it a private employer? What are the protections that we're talking about? Is it state? Is it local? Is it state, if it's governmental? We do have established whistleblower protections right now on the state level and on the local level. And local level was a few years ago as well. There is some question with regard to the state whistleblower statute, in that there may be narrow applicability only as it relates to the use of state funding. And that that may be an issue, but the bottom line on this is that there's no way to actually presume every single situation that's going to come up that may be affected by a subpoena situation. So if your question is whistleblower protection, anyone and everyone who may come in here and tell the truth, the larger question is, do we have a responsibility to pay people to do the right thing? And I think that the vast majority of us would say no. There is not. There is an inherent responsibility on the part of any witness to tell the truth, regardless of the circumstances. But I'd invite the lady's response on that, if the author doesn't mind.
I would say 3 things. One, whistleblower protections are designed to protect against an employee calling out illegal activity by their employer, and the whistleblower protections are narrowly tailored to do so. What this would expand is the compulsion of a person to come and testify, possibly in contrary testimony to testimony that has been given on policy by their employer. So you can have a person who is compelled to come and testify before appropriate. Let's take it out of this room to a room that we spend way too much time in as well. 341, in appropriations, a person can be called to testify on policy implications, because we don't constrain what they have to testify about. They can be compelled to come and testify about that, and it could be contrary to what the commissioner has put forward as his policy or her policy position, but because it's under sworn testimony, you're talking about potentially laypersons or lower level employees who are now giving testimony that contradicts their boss. There is nothing in our code right now that protects them from doing so, and in point of fact, they would be precluded from being able to not do so, because they are now being forced by subpoena to come and give that information. My second point would be that rare usage is, I think, an important thought, but we make policy based on what could happen, not what will happen. And my deep concern is that we are taking a fairly substantial step away from our normal practices, and we are creating an expansive body. I mean, I think it's a total of 9 committees that will have this, or 13 committees that have this purview. 13 committees comprised of political bodies and political persons who may be seeking, whether rightfully or not, to seek important information, and that information will reach beyond our normal scope of practice. So I don't think that we can predict how this could be used, because we have not seen it in the history of the state in this context. And so I do think that it is very concerning that we are allowing sworn testimony without constraining the type of testimony that can be provided, constraining whether or not it has to be factual based on numbers or verifiable empirical evidence. We don't set any standards for the type, time, or rationale for the information that's requested. We only require that the chairman, who is a political appointee by the body, makes the decision that it's appropriate for that to happen. And while I do believe that we all will act in good conscience, the language, if we say this code shall adopt committee rules, those committee rules will be voted on by persons, by us. And my deep concern is that, and that goes to my third point, that our standards, that this bill does not contain standards that limit or otherwise provide guidance to individuals who will be compelled to come and provide that testimony. I don't doubt the legitimacy and the veracity of the gentleman's intent, and I certainly don't disagree with the chairman that it's important for us to get honest testimony. My concern is that we are giving policing and investigatory powers to bodies that can compel individuals to speak against their best interest, and we don't provide them any protections therefore.
I mean, as a practical matter, just to go back, it's not the chair's discretion. It would be, at the will of a committee to adopt a rule, so that if a subpoena were to be requested, the committee would then vote on that pursuant to the rule to go to the presiding officer. Which, as we go on in the history of this state in the future, there will be shifts in power. There have been before. There will be again, which is why I share the lady's point that we need to step very carefully. But it's but it's not inherently political. Actually, it has to do more with the bill. It's not the chair's discretion. It ought not be the chair's discretion. It's the committee's discretion in adoption of a resolution pursuant to a rule to request of the presiding officer. That's a huge check, in the system, and a necessary one. The other point is about limits of testimony. 99 times out of 100, people are in here rendering an opinion. They are rendering an opinion. And, the question is, if you go ahead and set limits on what they'll be applicable for and what it won't be applicable for, it renders the whole thing moot, because then we're just not going to get the truth. What we want is the truth. And if the truth is based on their opinion, that's okay. There are varying opinions. That doesn't mean that someone is, testifying untruthfully. They're simply rendering an opinion. And I think that's where we may have a divergence. It's a healthy conversation, but I think if we get too narrow and too limited on it, then it's self-defeating. Then there's no reason to have it, which, I don't know, may be the intention. Mr. Coomer.
Thank you. Getting back to the subpoena issue more than the sworn testimony piece, I was going to ask the sponsor if he could give us an example of a time when someone had not responded to a request for information such that we would need a subpoena power in order to compel that. And as I was thinking and listening, it occurred to me that in January of this year, right after I got sworn in, I sent letters to agency heads asking about specific policy issues that I thought were going to come up during the session. And now we're in the middle of March, and I haven't received a response from any of those letters that I sent. Now, I will follow up on that, but I think the point is, excuse me, if we have subpoena power, we probably won't have to use it, because we'll probably get an answer to our letters and an answer to our voluntary requests for information. And I don't think we'll have to use the heavy hand of subpoena as much as we will have the specter of subpoena to actually get information that we're trying to get for legitimate purposes.
Well said. And I hate to use Congress as an example, regardless of who's in charge up there. But as a practical matter, that's exactly what happens in Congress. If there's a request for information, if there's a request for testimony, those people show up. And they show up and they render their best opinion they can based on the knowledge and information that they have and their experience, and that's it. And if they don't, then the chair of that respective committee may or may not issue a subpoena. Generally, it's not necessary, though, because people are showing up and telling the truth. Mr. Atwood.
Thank you, Mr. Chairman. That's exactly what I was going to bring up.
Sorry.
I've been actually on the receiving end of those. I participated in with teams that testified before Congress and others, and I don't know of any committee, it may be, that one, where the chairman doesn't have that authority, and two, where a witness isn't sworn. We expect you to go in and give testimony on policy issues under sworn testimony. oftentimes. And I did not see it abused. There may be cases, and I certainly don't like using Congress as an outstanding example, but they have flowed for years with this authority, and frankly, I've been amazed that we don't have it.
Thank you for the reality check.
We do have federal criminal statutes that make it a violation if you intimidate, influence, or any way a person testifying before any committee, any administrative hearing, or court of law. So maybe something we need to look at.
And one other point to make as well is that the false statement, the center for a false statement, that's pretty tough.
Mm-hmm.
It is very tough to go ahead and prove a false statement. And that's by design, and that's a good thing. Because if it were easy, then we would go ahead and chill testimony, which we do not want to do. That's the main thing we do not want to do, but we do want to go ahead and make sure we do get truthful testimony. It's a good debate. Let's do this, Mr. Davis. Let's go ahead and hold the bill for now. Let's go ahead and hash through, but expeditiously, come up with, I think the standard for quash is important.
Yes, sir.
I'm going to go ahead and recommend that we adopt an amendment pursuant to a new substitute that mandates adoption of rules as opposed to being a discretionary matter on a committee-to-committee basis. But let's go ahead and continue the conversation, but in a much more expeditious manner than we have. We are going to have another committee meeting. It'll be sooner rather than later. I just have to see what happens in subcommittees today before scheduling that. That will be scheduled, and the intent is to have this bill on that calendar. So that we can address this forthrightly. It's an honest debate. I think maybe there might be underreactions and overreactions, but I think it's an honest dialogue. So thank you for your time.
Thank you, Mr. Chairman.
Mr. Weldon, thank you for your patience. Mr. Sessler had to step out. I know that he'll be back. Mr. Coomer.
Mr. Chairman, I've got another committee meeting I have to attend at 11 o'clock, but I wanted to just make it clear for you and the other members that I'm supportive of this bill. In case I'm not back in time to vote for it, I just want to voice my support for the bill.
Thank you very much, Mr. Coomer. We appreciate that.
Thank you.
Mr. Weldon, again, thank you for your patience and look forward to hearing from you on House Bill 185.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, this is the Runaway Youth Safety Act. This bill provides an exception to harboring a child who's run away or not in the present custody of their parent. Looking on page 1, there's some modifications here. We've added in line 19, or an unruly child as such terms are defined in Code Section 1511(2). Then we delete the relating to juvenile proceedings. I don't believe that's necessary language when we reference the code section. On page 2, lines 26 through 28, we define service provider. A service provider in the context of this bill is someone who's registered in accordance with Article 7, which is attached to this bill, and I'll get to that in just a second, or a child welfare agency is defined in Code Section 49512, which is, generally speaking, that's folks who get referrals from DFACs when they have children they have to place in homes, group homes, things like that. And what this does is we're creating a new registration for private entities that are going to provide services to runaway children. And these children that we're targeting with this bill and they're intended to be served are not the children that have parents that are looking after them and they're on top of them. Many of these children are children that have left the home because they've either been abused or they've been psychologically or mentally abused, or they just been left out there to fend for themselves by the parents. And the parents, what we perceive, will not be pursuing these children, but these are just children that will be on the streets or homeless or runaways. And these are really pretty savvy children when it comes to being run away or not being caught in the net by law enforcement or the Department of Family and Children Services, and they know how to get around that situation. This bill provides that these private entities can provide services to these children who are out on the street without being afoul of the law. And if you'll follow me on this right here, starting in line 33, it says anyone who recklessly and, well, let me back up just a little bit. You commit the offense of interference with custody if you interfere with a parent's right to maintain a child or to maintain the custody if you entice the child away, which is one. We're not dealing with that provision at all, but subsection B in line 33, if you harbor a child who or a committed person who's absconded, then you've committed the offense of interference with custody. The exception here is for these entities. And number one, this is provided that a service provider notifies the child's parent or legal guardian regarding the child's location and general state of well-being as soon as possible, but not later than 72 hours. These children will be, it could potentially be, from the time they accept services from one of these child care providers, 72 hours at max, or otherwise they're going to be subject to interference with custody provisions. And if as long as they notify the parent or legal guardian within 72 hours, then they're not going to run afoul. But if you'll follow me down to line 38, the service provider, if they believe that a child's been abused or neglected, in accordance with the provisions of 19.7.5, then which we have here and it's available for you. What that says is you got to make a report within, at least an oral report within 24 hours, and that's incorporated here. If they believe there's some abuse, you got no more than 24 hours. You have to make a report to the department or a health care facility to make sure the child's taken care of. Then on down to line 40. If the child won't disclose their name or their parent or legal guardian, then these health care providers are going to have to make a phone call and contact to the Department of Human Services within 72 hours after the child accepts services. Number 4 would be, or if they make contact with the child's parent, guardian, or legal custodian, and it can't be reached, they'll have to make the contact with the department within 72 hours. So that's the max time. If they haven't passed 72 hours, then they're in jeopardy of running past the exception here. And that's part of why, and that's why we're bringing this bill, is we want to provide the ability for private entities to give services to these children for up to 72 hours, because they're not the ones that are currently being served. These are the ones that aren't being caught by police or law enforcement or the department and being put through the system and either placed in a home where they can be off the street and in a safe setting, but they're the ones that are out there and they're just growing up on the street. In section 3 on page 3, we define service provider, and this is the it's the exact same definition as provided previously, but this is the exception to contributing to the delinquency of a minor, because because of the way the law is written now, these child care providers can't give services without being at least at risk of running afoul of this section, or this law, because they could be contributing if they provide services or allow the child to be away from the parents. And then it goes through it's essentially the same exception to contributing to delinquency of a minor. If you'll go to, and that goes up to the top of page 4 through lines 100. Then in Article 7, which is the bottom of page 4, the registration of these private entities. And an example of these private entities would be a place like Chris Kids or Covenant House. And then we have Allison Ash here from Covenant House who's available for comment. The Article 7, this sets up the registry for these private entities, and they have to be a nonprofit 501c3 organization. And part of the reason for that is that's one step in a hurdle for them to get past. It's not somebody who just sets up shop right outside your neighborhood and says, "Hey, I'm going to try to catch all these kids." That's one hurdle, and it's not the intent of this of myself or the intent of this legislation to say that is, that's not the all to end all as far as a hurdle for them to pass, because 501c3s are available out there. You just have to go through the process to get them, but it does provide some steps. And they also serve children who have run away or children who are homeless, and this is on page 5. And they have a qualified staff on duty at all hours. The organization is open for service, and they employ at least one individual who's licensed pursuant to Chapters 10A, 26, 34, or 39 of Title 43. And that's social workers, that's physicians, that's psychiatrists, qualified people who have a license to lose. And I know I worked hard to get my bar license, and I sure don't want to lose it. So that's where we have the licensing procedures, and we got somebody on the hook there. And this they employ at least one of these individuals who are licensed, and they also have qualified staff. And a qualified staff will be someone who directly interacts with children, and those people will have training in child care required task and have the ability to care for these children. And the staff has also got a criminal background check, and that's on line 137. Now, if you go on down to line 139, this is where we get into the registration, and they're going to all be required to submit to the department on forms furnished by the department that'll provide their name, address, telephone number of the organization, emergency contact information. And then on line 144, registrant shall be required to keep the annual or to pay the annual registration fee of $25. And once the application is made, then the department will verify they meet the qualifications. Once they meet the qualifications, then they get a certificate of registration. The department will also have to go through their written policies, see that they have reasonable written policies to effectuate the care, and they have to show some proof of qualified staff. Have to have written policies. They can't be just, we got policies. It's whatever I say they are. But they have to have them written down. Whenever a minor comes into one of these registered organizations, they have to take a photograph of that minor for admission before they can admit that child into the care of the organization. They got to have liability insurance for coverage. They have to also provide a copy of its registration to the sheriff of the county. So that way the sheriff will know, and law enforcement will know where these entities are. And if Be on the Lookout comes in for a child that's been missing, they can just contact them. They can find out what's going on there. There has been with respect to that, there's been some discussion about whether once a child comes into one of these facilities, they should contact law enforcement immediately. And I submit to you that's not a good requirement for these entities to have to submit to law enforcement like that. The reason is, it's for me, when I began thinking about this, it was kind of difficult for me to get the concept of these children out there on the street, and they're savvy kids. These aren't kids that don't know how to make it on the street. They're the kids that they know how to make it on the street, but they may have broken a leg, they may have been hurt, and they don't know how to deal with that. I don't know anybody that does unless they're a healthcare provider. So if we require the notification of police as soon as they come into the entity or to the organization, then what's going to be the word on the street among all these children is going to be, look, you can't go there because they're going to turn you in just like that, and then they're going to stick you in a foster home. Then you got to go through that whole process, and then you got to run away again. So that's why, and that's why the limitation is in this bill that they have to be, they have to notify their parents or the department if there's no abuse within 72 hours, not later than 72 hours. If there is abuse, it's 24 hours. And I ask for your favorable consideration and certainly consider any questions.
Let me ask Chairman Setzler if you would just give us a brief report from subcommittee on 185.
Thank you, Mr. Chairman. This was this bill being in the full committee as a result of a, dare I say, mind-numbing slog through the subcommittee. It was. Do I have an amen?
That's a remarkable admission.
Do I have
against self-interest?
Can I get a witness right there?
I want an amen from the congregation on that. I will say, Mr. Chairman, to frame the issue from my perspective for the committee, the concern was the balance of parental rights, that parents be notified as soon as possible if these kids walk in these facilities, and that there be a bright line standard by which these facilities could no longer provide service. The problem to be addressed obviously is runaway youth that are on the streets. They've got a safe haven to go to if they're being, if they need a safe haven to go, but not in a way that some unaccountable entity could easily set up shop, entice kids in without any accountability from the law, and frankly be involved in somewhat murky and nefarious intentions without any accountability, any visibility, and that's the balance we try to strike. That between the current state of the law, which requires that licensed facilities, if a person under the age of 18 comes in, they've got to make in essence an immediate notification of defects, and the whole process of state custody kicks in. Young people know that they won't go to these facilities, so they really have nowhere to go. So what, in essence, I think we work through in the substitute you see here is a balance between the licensed community that does this today, where parents can consent for their kids to go, but there's no ability for a runaway to go into those facilities without being under the purview of the state. This gives it an interim period where parents are notified, again, in line 91. I think that the operative piece of the entire bill is notified as soon as possible. There is a duty for these entities to notify parents as soon as possible. But that if the young people aren't talking, they're not telling who they are, they're not telling who their parents are. Sometimes there's a need for a kid that walks in the door at 6 o'clock at night to have dinner, maybe let them sleep on it the next morning. There's a duty that the staff still has a duty to find the information as soon as they can, but sometimes it takes a day or so for kids to be forthcoming. And in that process, that very human process, how are we able to keep these kids off the streets while we try to get information out of them, try to reunite them with parents, and make an assessment with a licensed individual what the best interest of this child is. It's that narrow fringe that's not being served today, that frankly are being driven on the streets because the only place they can go is either back to mom and dad or to the streets or to the state. And very often these kids, we found through testimony, are not just running from mom and dad, but they're running from the state. Even if they haven't committed crimes, they don't want to be under defects. They might have been in group homes in the past. The last 3 group homes they've been in, they might think the people that they were placed with were kooky. They didn't like them. And this at-risk population, this gives them a place to check in while they're on the streets, to get a shower, to have someone to be a place to cry for help, and not just be left to sleep under the bridge and talk to the other folks, other young people on the streets as their only other support group. It tries to strike that balance.
Thank you, Mr. Setzler. I think that's a tremendously realistic, balanced, and mature approach to the issue that reflects real-world realities, and I appreciate your work on this and the subcommittee. It sounds like that's exactly the approach that we should take.
And Mr. Chairman, one last thing I'd say to again, what the statute does is rather than creating what we believe to be a too burdensome regulatory licensure process, we tried to balance that with nothing. Just allow a church to open its door and allow kids to walk in. We felt like that was too unaccountable. What we've got is this registration process requires there to be a licensed individual in their employ, and allow them to simply go through an inspection by the department that says, do you have a written policy? Do you have a licensed person on staff? Have you met these criteria of criminal background checks for all your employees? If these, by finding of fact, are in fact the case for you, then you make it on the list. And as long as you're on the list, you can operate. You're not licensed, you're not regulated, but it's more of a registration process that's a balance between no accountability and the burden of licensure.
Thank you again. Mr. Pack.
Thank you, Mr. Chairman. My comments are much more technical than Chairman Setzler's. On line 34, I noticed that you're providing an exclusion to the criminal statute, and it says it shall not apply to a service provider. I'm thinking maybe, looking back at the definition service provider, 26 to 28, whether or not you should consider adding the words or their agents. Because honestly, if anybody's going to be liable, it's probably going to be the worker at the service provider, not necessarily the service provider itself, although theoretically that is possible. Secondly, I wasn't quite sure reading through this if this is in fact going to be an affirmative defense, or if it's just going to be one of those elements that are not, that the prosecutor has to prove. You see what I'm saying? So either you have the prosecutor proving that they're not a service provider or their agent, and they did not do these things, or is it the burden on the service provider to prove that we did these things to escape liability? And I wasn't quite sure on that. And one last comment is, with respect to, this is a straight black line about notifying the parents. I was wondering if softened language of a good faith attempt would be even better, instead of just. But I'm not so wedded to that, because I could kind of foresee that it's not going to be in practice. It's not going to be such a black and white type of thing when someone did try to contact, especially in light of a child that probably doesn't want to cooperate and kind of savvy in your sense, but that provides that safe harbor for the organization. And I think the last comment I will make is on line 46, and I think I talked to the Barton Law Clinic people about this. I think the intent is you try your best to contact the parents first before calling DFACS. But if it limits the hours for line 46, that you have to call DFACS within 72 hours, the practical effect is I think you're going to call DFACS at the same time that you try to reach the parents, because if you try to reach the parents within 72 hours and can't get a hold of them, you want them to keep trying, then 72 hours is up that you can't call DFACS. Does that make sense? It might have to provide a little added couple hours or something for contacting DFACS after trying to contact the parents. Those are my suggestions. Otherwise, I support the bill.
Thank you. I think that can I go back to line 34? I think that's I'd take that as a friendly amendment, or their employees or agents of the the service provider, to a service provider or their employee.
Mr.
Setzler. To Representative Pack's friendly suggestions, I don't know that an agent of a service provider in and of themselves represents a service provider, because I believe the word service provider is used in the bill. I'm struggling to find a place.
think line 26 and through 28.
Okay. And Mr. Chairman, if Ms. Abrams can elucidate that, let me address one of the other questions of Representative Pack. The good faith effort and the 72 hours. The subcommittee wanted a very strong statement of a duty to notifying the parents as soon as possible. There's language down below that talks about if the parents aren't able to be reached, then in 72 hours there's a process that's kicked in. Mr. Chairman, maybe I need to ponder a specific remedy to his concern. I will say generically there was a desire to be very specific and very prescriptive. I will say the 72-hour bright line was a desire of the subcommittee. There be a very bright line that as you're getting up to the 72 hours, you know it's coming close. You've got to take action. We've got a duty to make sure that 72 hours can't blur into 96, and then kind of there was some concern in the subcommittee that maybe 72 should be 24 or 48, and 72 was kind of the long end of that, I think there was an intent to make that a very bright line. I don't know that there was an interest, at least in the subcommittee, of that being blurred in any way.
Ms., did you have author of a comment, and then I'll go to Ms. Abrams.
If I could address the good faith effort that Mr. Pack and Mr. Setzler addressed.
Okay.
I think that if we put it in there, that will state clearly what frankly, I didn't have that in there, and it's a great catch. I appreciate that. It is, to me, it's implied that it's a good faith effort, because we have licensed people, we have people that are registered, that care for that. That's the point of what they do, is to care for them. If we leave out the good faith provision and effort in making contact with the children's parents, then that's one thing that doesn't provide more guidance that I think is reasonable within the scope of this bill for contacting parents. Now, when it comes to contacting the department, there's a drop dead date, and they go past it and they haven't done their duty, then they're running afoul of statute, and they're outside of the exclusion. And with respect to Representative Pack's issue regarding the proof by the prosecutor, I think that if someone is on the list that they're registered, then I think they have to prove that they did, they followed the procedure here. If they're not on the list, I don't think this is going to apply to them, and I don't think that they wouldn't. If they're not registered, then the prosecutor wouldn't have to prove it. He'd have to show it'd be as if it wasn't there, and that someone if they were, absconding or enticing a child, that they would be in violation of the statute, both of the statutes.
Well, let me do this just for purposes of time. Obviously, when we get to a motion, the bill will be subject to amendment at that time, and members are neither encouraged nor discouraged as it relates to that process, and we'll just work through it. I promise, Ms. Abrams.
Well, you may want me to hold. It was to clarify the amendment, the friendly amendment. I would just request that instead of putting it on lines 34 and other places, that we actually expand the definition of service provider to say an entity or employees or agents acting on its behalf. My concern is if you give them separate standalone, separate standing within the provisions, they can act outside of the intent of the service provider, and I'd rather we limit their ability to have independent support or take independent action to putting them within the definition of service provider.
Does the author have a comment on that?
I think that'd be a friendly amendment. I think it's an improvement to the bill.
Very well, Ms. Neal.
I just had one general question. Because now, is there something in here that makes it where the actual agency taking the children can possibly remove them off of GCIC and remove them from the National Center for Missing and Exploited Children, because if they're never reported, those kids stay on those databases, and the detectives that are all throughout Georgia are still assigned those cases, and they never can clear them if the children are never reported and never taken off.
There's in this statute, I think there's when some of the savvy children are do take advantage of these services, the maximum time that an agency or a registered 501c3 organization would have the exception to this would be 72 hours from the time that child accepts services until the child is either returned to the parents, contact made with the parents, or the child is turned over to DFAC, or contact is made with DFACs regarding the child. If the child goes back to the parents, I guess there's an assumption that that'll resolve the issue. Okay. Yeah. And if the child goes into the DFAC's care, then DFACs would have the ability to
You're right. That's the solution. Either the parent can then clear them, or the DFACs can clear them. That's fine.
If they go back to the parents within 72 hours, then then that hopefully will resolve the issue, and then it'll stop the manhunt and stop the GCIs.
Right, because I know that the National Center for Missing Children, they put the stuff up on the billboards, and you have all that stuff going on, and the kids are already found.
Right.
Yeah.
Right. So hopefully that'll address that, but I appreciate your comment on that. Thank you.
Ms. Benfield, and then we'll get to a motion.
Just a quick concern, and I've shared this with you. I got an email from a constituent who has dealt with a runaway child, and unlike a lot of these scenarios, she really is a caring parent and has had a lot of trouble with this child. And she wanted to make sure that the police, law enforcement were aware of these facilities where they could take children. And to that concern, I was looking on line 161, and this provides that a copy of the registration of these facilities be given to the sheriff. My question is, in counties like that I represent, DeKalb, it's the police that tend to be the law enforcement on the streets more so than the sheriff. The sheriff patrols they do warrants for arrest and serve subpoenas and stuff like that. But as far as on the streets, it's the police. So should we consider adding to the sheriff or the police? Sheriff and the police, sorry. Thank you. It's page 5, line 161. I just want to make sure that the law enforcement agency that's actually on the streets and most likely to be picking up these runaway children is aware of these facilities and where they're located.
I appreciate your concern, and that was one of the things that I kind of wrestled with a little bit on that. The reason we put sheriff in there is because there's at least one sheriff in every county, and they'll have jurisdiction over that type of issue. If in this situation, if the police, all they'd have to do is make contact with the sheriff, and they could get a copy of this right here, a copy of the registration. And hopefully what's happening is they're communicating in the jurisdiction where you have the sheriff. We have overlapping jurisdictions there, particularly with this type of issue. I think it becomes cumbersome if we expand it outside of the sheriff's office, because you're going to have it makes it very difficult if we just put a police in there, because you could have several different cities in one county, and these entities would be at risk of not complying with this provision if we put police in there. And if they go to, let's say they're located in Lawrenceville, or and they don't report it in another city to the police department there, they could run afoul of not complying with this provision. I think that when it comes to this kind of situation, that there will be communication when there's a child being looked for between police and sheriff's department, and it would not that it would always happen. It certainly could fall through the cracks, but parents that are looking for their children, they're going to be contacting the sheriff, the police department from, I can't think of any police department I wouldn't call about my kid.
If I could just briefly follow up, I'm more.
Yes, briefly. Then we go to Ms. Neal for a quick comment on the law enforcement issue, and let's get to a motion.
I'm more concerned. I want to make sure that the police are aware that these facilities exist in their community, so that if they pick up some of these children, they have a place to take them. That was my constituents' concern, and this does not require, in counties such as DeKalb, that the main law enforcement agency get a copy of the registration of those facilities. So maybe have the sheriff require that the sheriff provide a copy of the registration to the police within their jurisdiction would address that concern.
Or if we could require that the entity, the child care provider, provided to the police department, for which it is subject to, where it is in their jurisdiction. Maybe that would address the issue. I might need to think about how to word that.
Okay.
Ms. Neal.
To that, I kind of agree with Ms. Benfield. Like in my county, no one called. I mean, they could probably call the sheriff's department for it, but they say call the police department. There's no link there. We handle, and mostly the police, which is usually going to be the investigating authority, because like she said, as far as warrant service and things like that, that's what they handle. And a lot of sheriff's departments, especially if they don't have a police agency in their county, they don't even have the means. They'll have no type of division that can handle it. So even if it's like she said, the sheriff's office would then be made to provide that list to the police department, I think that would actually take care of the problem. Because right now the two don't converse like you would think.
So, and just so I understand, the concern is for the police department that has jurisdiction over the entity, the organization, the 501c3 organization, or the other child.
Or just have knowledge of it, like she's mentioning, because, like I was saying, and even including overnight hours, if the sheriff's department doesn't even have a unit to handle this, the police department probably won't even find out to the next day about what additional resources she's mentioning. Because like in my county, it's only like Rainbow House. It's like I think that's the only one from my county. But if I don't know there are other entities that are available to us that we can locate the children, we're probably never going to know unless the sheriff's department provides us with that list.
Okay, so if we had the sheriff's department disperse a list, okay. I understand. I'm not averse to that. Okay.
Mr. Vice Chair.
Thank you, Mr. Chairman. As you know, I'm supportive of the bill, and we worked pretty hard in subcommittee in making this, I think, a much better bill. One question that has come up, though, that I wanted to ask you about: would 501c3s under this bill now be eligible for any state funding, or would there be any state funding going to the 501c3s as a result of the passage of this bill?
No. There's no provision for any appropriation under this bill for any of these organizations.
Okay. Would they be providing any services that anybody else, that say a licensed provider, gets state funding for now?
Yes, they do, up to 72 hours. And the services they would be providing would be allowing a child to come in, stay, some food, a place to stay, some shelter, that type of thing. They will have other individuals who are licensed, just like in the longer term facilities, group homes, things like that. They'll have people that are there and they're going to get information out of the child that necessarily to comply with the statute, to contact the parents and DFACS, and they're going to take a photograph of the child.
So it's not your intent that these organizations would, at any point in time, ever be receiving any state funding?
Clearly, yes, and that's part of. I'm sorry.
Would you be averse to having an amendment to say just specifically that these organizations would not be should not be or would not be the recipient of any state funding as a result of that designation?
As a result of this, the registration. Some of the
I mean, and I don't mean to interrupt, but the concern is that has been raised to me was that we may be, although it's not in this bill, that at some point down the line we may be opening up the door for state funds to flow to the 501c3s who are registered under this bill. Do you have any feeling about that?
There are, in the definition on line 26 through 28, there are service providers that are defined in this statute that already receive referrals from DFACs in their long-term care providers.
You mean non-licensed?
No, that are licensed.
That are licensed.
So you're just referring specifically to unlicensed,
right? Just to those that are not licensed. Would you be averse to having an amendment that says that they would not be the recipient of any state funding, or would that create a problem in some other realm?
That that gives me a little pause because there may be some just merely unlicensed. The only provision that would apply to, or the only entities that would apply to would be the ones that are registered and are unlicensed.
Correct.
I'd probably need to think about that just a minute, just to make sure there's not any other programs that we have, and I don't want to cross up just because they're providing this sort of service, and if they're receiving funds from another program.
Well, I think it would behoove us to consider this at this point, because assuming the bill gets to the floor, that's probably an issue that may be raised, and I would think we wouldn't want to open up a whole new category of state spending merely by the passage of this bill.
Sure.
And I don't know if that's a concern or not. I'm just asking the question.
This bill, I don't think, provides. Well, I feel confident it doesn't provide for any appropriation or access for appropriations. I think it'd have to be another bill specifically to provide that issue or provide funding from the state to these. Just on first consideration, it seems like that may be just a little bit outside the scope of what we're trying to do here, where we just provide the ability of entities private entities to provide services to these children, and part of the reason we want them to do it is because it'll be less that the state has to take on, and in addition to the primary focus of these children getting services.
Right, and I think that's a laudable purpose, but if we're going to provide an exemption for these service providers, their employees, from the criminal liability under the law that we have now, and we're specifically providing for their registration, but at the same time, if we're giving them that authority and we're taking that burden off the state, I wouldn't think it wouldn't be helpful unless you make sure that state's not going to be spending the same amount of money to do that.
Sure.
I guess.
I have sitting with me an expert, and this is Taylor Dudley, who's from the Barton Clinic, and if I could just ask her to comment on that, I believe she may be able to.
Ms. Dudley, please do so very briefly. I want to go to Mr. Coomer quickly, and then to Ms. Abrams for a motion, because we're going to lose counsel in about 5 minutes.
Okay.
So I want to get to a markup and amendments while she's still here.
Thank you, Mr. Chairman.
Thank you.
Just briefly, I think that the provision would give us some concerns, given that some of these organizations receive funding in other ways for other purposes. So if there were to be such a provision, it would have to be narrowly drafted as to ensure that other funding that's available wouldn't be ruled out.
All right, Mr. Coomer.
Just to follow up on that and to get a little more specific, we're talking about existing shelters, in many cases, homeless shelters for families and for adults who have not provided this service to children coming alone because of fear for criminal prosecution, correct? And so it's conceivable that some of these facilities may be receiving some kind of public grants already, and to create that kind of impediment might actually undo the entire purpose of this bill, which is to encourage them to provide those short-term services. Is that correct?
Certainly, Representative Kummer.
Thank you.
And to that point, just as so long as it were narrowly drafted as to avoid that effect, there could be such a provision, but we'd have to be very careful about the language.
Thank you.
If I could, Mr. Chairman.
Very briefly.
I believe we can come up with some language to do that, and just as Ms. Dudley stated, that if we narrowly tailor it to this registration, I think I believe we could work something out with that. I think we could work some language in that.
We may not be in a position to do that right now.
Okay.
With regard, I mean, if it's in the context of a Rules Committee amendment under a structured rule, that's a possibility.
Okay.
That begs the question of is it truly necessary? I'm not encouraging or discouraging on that. I would encourage you to have that conversation offline with members who may be interested to make that determination first. If the answer is yes, then we can look at it in the context of an amendment under a structured rule.
Thank you, sir.
Mr. Sessler, did you have something?
I just to the author, I would remind the author that not only is what's addressed in this bill or the registered entities, but the licensed entities that are already providing services that do receive dollars, and for us to, I think it would be problematic for your proposition if that were offered. I don't think, and I don't know that Representative Hatfield. Well, I don't know that I see that as essential to the passage of this bill, either in committee or on the floor. And I think the problems that are created, the unintended consequences of that would be potentially prohibitive.
I appreciate your comment on that, Mr. Sessler.
All right. Thank you. Mr. Sessler, Ms. Abrams, you ready to go?
I'd like to move do pass HB 185 LC 294717 ERS.
Ms. Abrams moves due pass of House Bill 185 LC 29. Is it 41 ERS?
4717 ERS.
I got my top of my page got cut off. 4717 ERS. Second by Mr. Sessler. Any further discussion? Any amendments?
I think Ms. Travis has drafted Mr. Pack's amendment, and it's actually closer to what you wanted, so I think she's got it.
All right. Mr. Pack, do you have that amendment handy, or does Ms. Travis have it?
Ms. Travis has it.
Okay.
The one.
If you have it under
line 28.
Let me ask you this: is it in a format where we can make quick copies?
It's like 4 words.
Oh, okay. Ms. Travis, let me ask you to crane over to the mic if you could, and.
Line 28, after the word, or after the 49-5-12, add or an agent or employee acting on behalf of the service provider.
Or an agent or employee acting on behalf of a service provider.
Of the service provider.
Okay. Could you read that one more time?
Or an agent or employee acting on behalf of the service provider.
Is there objection to the amendment? Is that not clear to any member of the committee, first of all? Is there any objection to the amendment? Seeing none, the amendment's adopted. Any further amendments, Mr. Pack?
There's one more on line 80, I believe. We probably need to add the same language. On page 3.
So to be clear, the language of the amendment that was just adopted on line 28 to be added at the end of line 80, is that correct?
Yes.
Okay. Is that clear to every member of the committee? Is there any objection to that amendment on line 80? Hearing none, the amendment's adopted. Are there any further amendments?
There's one additional.
Ms. Abrams.
At the end of line 162. Striking the period, inserting a comma at the end of that line, and adding, and the sheriff shall distribute such registration to all appropriate law enforcement agencies within the county.
Let me ask the author about that.
I take that as a friendly amendment,
okay,
Mr. Chairman.
Let me ask the author to read the amendment one more time again, line 162.
Comma, and the sheriff shall distribute such registration to all appropriate law enforcement agencies within the county.
I just want to make sure you're caught up on that.
Yeah.
Okay.
No comment after the facility, though. It's all one sentence. You don't need
Okay. So we don't need the comma on 162. Could counsel read back the amendment, please?
And the sheriff shall distribute such registration to all appropriate law enforcement agencies within the county.
We didn't hear from the Sheriff's Association during testimony. Is there a representative of the Sheriff's Association in the room that wants to be heard on that particular amendment? Okay. Thank you. Sure. That's reasonable. Thank you. Any objection to the amendment? Seeing none, the amendment's adopted. Are there any further amendments? Seeing none, we'll go ahead and pass that by substitute then in the nature of a fresh substitute.
Yeah, I think we have two minor other corrections.
Okay.
Line 37, the word change service to services to be consistent with lines 42 and 46. And on page 6, line 176, change the word child to minor.
Any objection to those technical amendments? Seeing none, they're adopted. Are there any further amendments? Seeing none, we'll, and in the nature of a fresh substitute, all on the gentlelady's motion of do pass by substitute, HB 185 LC 294717 ERS. All in favor, say aye. Aye. Opposed? The ayes have it. The motion's adopted. Thank you very much, Mr. Weldon, for your time and patience.
Thank you, Mr. Chairman. Thank you, ladies and gentlemen.
And let me thank Representative Allison for his time and patience, too. And we'll go ahead and take up 372. We'll take a minute for the room to clear. Well, that's the curse of having an easy bill. Sometimes it can go early and sometimes it can go late, but it can go.
I'm so tired, y'all can table next year for me.
All right, let me ask the room if it could to settle down. We've got one more piece of business. It's House Bill 372 by Representative Allison. We thank him again for his patience. And the floor is yours. Thank you.
Thank you, Mr. Chairman. I'm trying to figure out how I'm going to follow judiciary subpoenas and the youth runaway bill, but I will try. I bring before the House for its consideration House Bill 372. This was a bill that was brought to me on behalf of my local clerk of Superior Court. What this bill has to do with is simply unclaimed cash bond. When a criminal defendant or an accused comes in and pays a cash bond for any type of criminal matter, if after the disposition, after his case is disposed of, whether it's a plea bargain, pretrial diversion, or the case is just closed, oftentimes defendants do not pick up their cash bonds. These sit in the treasury of the county clerk for year after year after year. Of course, we know that clerks have a fiduciary duty over this money, and for many clerks, it's really gotten to be a significant problem. Under current code, a clerk has to wait 7 years before they can distribute that money over to the county treasury. What we're proposing in this bill is very simple: reduce the time it takes the clerks that they have to manage and control this money from 7 years down to 1 year. All of the safeguards that are currently in law will still be there. The clerk's office will have to notify the defendant within 90 days of disposing of the funds that this unclaimed cash bond is sitting in the treasury. If that person does not claim it and the time period elapses, they simply turn it over to the county treasury as now. Actually, I think we have an opportunity here right now. Several of these folks who pay cash bonds and don't collect them in the long run, they will no longer be anywhere near where they're living 7 years later. This is moving it up and allowing them to dispose of those bonds sooner. It also puts the onus on the clerk to let them know sooner. So that's simply what this bill does, Mr. Chairman. I'm happy to answer any questions.
Ms. Bird. Yes, ma'am.
Thank you very much. I do have some questions.
Sure.
All right. First is, are there any presently guidelines as to how cash bonds are handled?
I guess if you're talking about how they're handled, they go into the treasury of the clerk, just like they're holding. The clerk of the Superior Court will hold on to the cash bond until disposition of the case, because that is the surety that they will show up to come to their court appearances. Obviously, if the only way that this code section would not play into consideration is obviously if someone would not show up for a public hearing and their bond may be forfeited, something like that. But right now, cash bonds are placed into the treasury of the clerk's office. They have a fiduciary duty as the clerk of Superior Court to manage that money.
Further question, please.
Sure.
Can the forfeited cash bonds be remitted to the surety once it is paid to the general fund?
No, run that one by me again. I'm sorry.
And these are questions that have been sent to me, so I would like the answers.
Okay.
They want to know, can the forfeited cash bonds be remitted to the surety once it is paid to the general fund?
I don't think anything in code says that couldn't take place. I do know that one of my clerks, he has released money that after the time period, a person has come back and said, "Hey, my money's gone back." What he does is, my clerk in one of my counties, if somebody has lost a forfeited cash bond, it's been turned over to the county, they petition the county, and my counties have given this money back. But I don't think there's anything in this statute, and this wouldn't change anything that's in current law about what happens in that case. I simply don't know. Because if it's after current law 7 years and someone's money has gone back to the county treasury, I have no idea what the law is about getting that money back. It's turned over to the county treasury. I guess it would be up to a county by county basis. That's not really affected by this bill, I wouldn't think.
All right, and one other question
Sure.
I need answered is, if such forfeited funds were paid into, is it possible for these funds to come to the general fund for the state of Georgia?
No, it goes back to the county treasury.
So
the county in which the defendant is on trial, if it's Cherokee County, if they have a DUI in Cherokee County, they post a $1,000 bond, their case is disposed of, and they never claim their bond. And under law right now, if 7 years goes by and they don't claim that, they're sent notice by the clerk. If they still don't come back within that 90 days and claim it, the money is forwarded to the Cherokee County Treasury to be used by your county. It has nothing to do with the state.
Very good. Thank you.
Ms. Banfield.
Thank you. Representative Byrd, I got the same email, so I don't have to ask those questions now. I just have a general question about the history of this bill. Do you know where the 7 years originally came from?
No clue. This was brought to me by...
Do we have someone who knows that?
I have no clue. This was brought to me by one of my clerks in White County.
Gotcha. Okay. I was just wondering what the rationale. If I may ask a... I didn't say that. That's helpful. I'm just curious the genesis. And two very quick follow-ups. Does the Superior Court Clerks Association have a position on this, and have you heard from bail? Well, actually, bail bondsmen wouldn't be involved in this. Is that 'cause
most
it's
bail
cash?
bondsmen that would post cash bond would know right away to get their money back.
Yeah. So, but have you heard from the clerk? I know your clerk.
I've met
approached
with
you.
several clerks. I don't know where the association on this. I can't imagine them objecting, but you never know.
Okay, thank you.
And I talked to their lobbyist, which I thought was going to be here, but I have not seen him.
I know. I was looking for him.
Yeah,
but-
I was notified last night that he was going to be here, but he's not here.
I see no
thank
further
you.
questions. Is there anyone else like to be heard on House Bill 372? Seeing none, what's the pleasure of the committee? Move to pass by the Vice Chair, second by Mr. Coomer. Is there any further discussion? Any amendments? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted.
Thank you, Mr. Chairman.
Thank you. Representative Weldon, Mr. Sessler, is ready, willing, and able to go ahead and convene his subcommittee quickly. I understand that the word quick is involved on 184, if you're prepared for that.
Mr. Chairman, I'm in the process of getting the amendment right now printed out so we can have that, and it's not. Okay. I don't think I'm ready for it right this second.
Okay, let's do this for members of the Sessler subcommittee. Why don't we go ahead and take a half hour to 12:30? Mr. Ramsey, is that all right with you? So we can step next door. That gives time for the amendment to be printed, make sure everything, the T's are crossed, the I's are dotted. The Sessler subcommittee can come back at 12:30, do its business, followed by the Ramsey subcommittee. Is there any objection to that? Is there something we're not thinking about? Upon the conclusion of the Sessler subcommittee, which should take all of about 10 minutes. Okay. All right. Great. So we'll say the Sessler subcommittee in this room at 12:30.
We're just averaging things out.